Thank you for joining us. My name's Andrew Ryan. I'm the one with the big R behind me on the wall. I work for 1825 in our County Durham office. I should start by letting you know that this session is being recorded as we plan to distribute it to our clients that haven't been able to attend. Please don't worry about this. No names or faces will be on the recording other than those of us that are hosting and presenting. As I mentioned, I work for 1825 Financial Planning. Joining me is Jonathan Bray, one of my colleagues at 1825, and also Samantha Edwards. She's a director and solicitor from EMG Solicitors. Jonathan and I are both financial planners with 1825. We work with clients across the North East, though as a firm we have various offices throughout the UK. As a business, 1825 provide holistic financial advice, which means that we advise on all aspects of financial planning, including investments, pensions, inheritance tax, and income tax planning, though it is fair to say that we spend a lot of our time advising clients in the retirement space as they plan for, transition into, and hopefully enjoy a long and healthy retirement. Samantha from EMG is a director and solicitor. She specialises in private client work. EMG are an award-winning Legal 500 firm who specialise in private client law and have a particular expertise in wills and later life planning. EMG have offices in Durham and Newcastle, and Samantha is a director at the firm and also heads up their wills, trusts and probate team. Samantha's been practicing for over 13 years and has extensive experience in advising clients. She's recognised as one of the leading lawyers in the North East in terms of estate planning, so it's really good to have her doing today's session with us. It's important to note that whilst 1825 and EMG enjoy a strong relationship, we aren't tied to each other in any way. Both 1825 and EMG work with other trusted firms to benefit clients. So, on to today's session. We will make sure that we don't keep you for any longer than an hour. Firstly, we'll hear from Samantha at EMG, who will be talking to us about protecting your wealth. We'll be discussing inheritance tax, the residential nil rate band, gifting, both during lifetime and through wills, and importantly, how all of this can interact with care fees. The aim of this session is really to help you in prioritising your goals and ultimately understanding where you need to seek advice to ensure that the actions that you take have the desired effect. After Samantha's session, we'll hear from Jonathan. Jonathan is a pension specialist at 1825, so it won't come as any surprise that he'll be talking about pensions. We'll be providing an overview on the taxation of pension funds after death, with a focus on ensuring that your pension assets are passed on to those you want to benefit most. Jonathan will touch on the planning that can be done in this area and hopefully provide you with some thought-provoking content that you can pick up on in future discussions with your financial planners. Throughout the session, if you have any questions that you would like answering at the end, please use the chat function and we will pick up these with a brief Q&A. Alternatively, if you have any questions that you'd prefer to have answered in private, please contact either myself, Jonathan, or Samantha after today's session, and we'll be more than happy to help. So, without further ado, I will pass you on to Samantha at EMG.
Hi there, everyone. I'd just like to extend my thanks as well for joining us. And just as Andrew said, I am a solicitor who practices in wills, trusts and probate. And today, as he's mentioned, I'd like to talk about inheritance tax and really the protection of your estate going forward, whether it is from tax or financial assessment. I think the first topic really to start off is inheritance tax and the residential nil rate band that was implemented by the government from the 6th of April 2017. So let's talk about how this interplays with the nil rate band. So every person has a nil rate band which is worth £325,000, and that's the sum that you can leave to anyone tax free. But if you're a married couple, then you can leave your estate to the survivor, and you're deemed not to have used that nil rate band, so that it, on the survivor's death, it can be transferred forward so that the survivor has their own nil rate band and 100% of the first to die's nil rate band, which gives gives £650,000 passing tax-free on the survivor's death. Now, the residential nil rate band also gives a further £175,000 per person, and it is transferable just like the ordinary nil rate band. So again, if you leave everything to each other, on the survivor's death, you can have the transferable nil rate band and a transferable residential nil rate band. So 175,000 times 2, we get 350,000, plus the 650,000 I talked about just before, and you get £1 million passing tax-free. So the residential nil rate band can be very useful, but it has a number of qualifying conditions. Unlike the nil rate band, which is there for everyone, the residential nil rate band can only be used if, for a start off, you have children or stepchildren, because it must be what's called closely inherited. So you cannot leave part of your property to a niece or nephew or to any other family member unless they are a direct descendant. You can't claim the residential nil rate band unless you leave it down to someone who is closely inherited. The other qualifying condition is that your estate must be under £2 million. Now, that's obviously a large amount, but it also includes any assets that qualify for business property relief or agricultural property relief from inheritance tax. So whilst an asset that may qualify for these reliefs may not be taxable on your death, the value of them is included in the calculation as to whether you qualify for the residential nil rate band. However, if you make a lifetime gift, obviously in your lifetime before death, even if it's within 7 years, the value is out of your estate for qualification for the residential nil rate band. It may still be taxable when we add it back in, but it is taken out of the calculation to qualify for that extra £175,000 per person. The other qualifying condition is that you must own a residential interest at the date you die. So the property that you have lived in, whether at the time of death or at some point in your life, must be in your estate. And to qualify for the full £175,000, or for the survivor the full £350,000, your residential interest must be worth that sum. So if you have a house which is worth £300,000, the survivor can only claim £300,000 of residential nil rate band. If your house is only £100,000, you can only claim £100,000 worth of residential nil rate band, but the maximum is £350,000 for a couple. Now, the other very useful part about the residential nil rate band is that there are what's called downsizing provisions, so that if you live in your large family home now, and as you get older you want to downsize, so you no longer own that property, so it may be worth £400,000, your family home, and you sell to a smaller property which is now only worth £200,000, as long as we keep a record of the fact that you have downsized, you can claim the full residential nil rate band rather than just the £200,000 that your new home is worth. So keeping records of the sale of a residential property is really important. And what I would tend to do, where I have a client, I work in conjunction with our residential conveyancing department, and we would keep a copy of that transfer with your will so that we had the proof necessary for HMRC. This also works if you were to go into care as well. It's just the proof that we need to prove to HMRC that you did own a more expensive property before. So I think they're the main points about inheritance tax. So let's move on to gifting in lifetime. And let's firstly look at the reasons for gifting. So as we've just talked about inheritance tax, one reason that people gift out of their estate is to reduce the value for inheritance tax or reduce the value to ensure that they can qualify for the residential nil rate band. So for inheritance tax, we want to, if it's a couple, we want to try and bring the survivor's estate under 1 million. And if you have a larger estate, for the residential nil rate band, we need to bring your estate down under the 2 million mark. The other reason that people gift is to try and reduce their estate value because they may have to go into care. Now, whilst this is under the new Act, and I'll go into this in more detail, maybe deliberate deprivation, there are certain gifts that can be made that may not be thought of as such. But I suppose the reason that people are doing the gifts, whether it is for inheritance tax or for care, is trying to protect their estate for their beneficiaries or for their children. So let's quickly look at the different types of gift that can be made. Now, if you were to say you wanted to gift a capital sum, so you had £20,000 and you wanted to gift it down to your children or down to your niece and nephew, then you could gift them that cash and it would take 7 years before the value was outside of your estate for inheritance tax. And that's what's known as a potentially exempt transfer or a PET. So the date that you gift, 7 years elapsed, and then after that, the value is out of your estate. If you die within the 7 years, if it's only £20,000, it utilises the first part of your nil rate band. If, though, you gifted more than your nil rate band, so you gifted £350,000, then, and you died within 7 years, then your nil rate band would utilise £325,000, but £25,000 of that gift would be taxable. And the tax payable, and the tax on that 25,000 is payable by the recipient of the gift, by your child or niece or nephew or whoever it was. There is taper, so the longer you survive, the less tax you pay, but it's something that often people are not aware of, that it is the recipient of the gift that pays the tax and not your estate. The other type of gift is where you gift into trust, and that's a lifetime chargeable transfer, and that has the same 7-year clock attached to it. Now, a lifetime chargeable transfer with a gift into trust can be taxable at the date you make the gift if you gift more than £325,000. So again, if you put £350,000 into a trust in your lifetime, the £25,000 over your nil rate band would be taxed at 20%, which is the rate of lifetime inheritance tax. If you then died within 7 years of making that gift, the other 20%, taking you up to the 40% inheritance tax rate, would be payable by the trustees. The other type of gift I'd like to talk about, because it is relevant especially when we're thinking about care, is a gift with a reservation of benefit, or a GROB. Now, this is where, for instance, you gift something but continue to benefit from it. And one example is where you gift your house, but you continue to live there rent-free. Well, that is you reserving a benefit in that property so that the value of that property will always be in your estate. It doesn't matter how many years have elapsed, 7, 8, 9, 10 could have elapsed, but the value will still be in your estate because you've reserved that benefit of living rent-free in your house. In order to ensure that a gift of your house is not a GROB and not still in your estate, regardless of the years that have elapsed, is to pay a market rent. And so that's only really an option where you have a lot of income coming in. I'm not going to talk today about gifts out of excess income, but if you do have any questions, I can go through those as well. So I think they're the main types of gift that you can make, and they can help to reduce your estate value, but you need to think about the effects of these, especially if you were to die within the 7-year period of making them. Now, the other thing about the residential nil rate band is that you could make a gift for instance, of £100,000 before the day before you die, and that value will reduce your estate for the qualification for the residential nil rate band by £100,000. Yes, it will still utilise your nil rate band, but you may still qualify because you've brought your estate under the 2 million, so that you get the extra 350,000 or 175,000 passing tax free. But there is a conflict between trying to plan to qualify to meet the residential nil rate band conditions and to plan for care. And that's because of the closely inherited rule that I talked about. Because you have to pass your interest to a direct descendant, when you pass it into a trust, and I will talk about these in more details, but particularly a discretionary trust, it's not deemed to be closely inherited. And therefore, if your house is within the trust, it may not qualify for the residential nil rate band. So let's now talk a little bit about how we can try and protect your property from any future financial assessment. And I'd like to talk about in this section a bit about a lifetime gift of your property, and then moving on to gifting your property in your wills. Now, before the Care Act 2014, gifting your property in life was a lot more prevalent than it is now. And that's because of the different restrictions that the Care Act has brought in, and I will talk about those. But let's think about gifting your property. So you live in the property, it's your main residence, and you decide, well, I want to take it out of my estate. What can I do? Well, as I've said before, any gift of your property, whether it's to children or whether it's into trust, will be a gift with a reservation of benefit if you live in it rent-free, so that it will always be in your estate for inheritance tax. But we often use this type of gifting to try and take the property out of your estate for care fee assessment. Now, if you gift to children and they are then on the title to your property, you can still live there, but you live there according to their rules because they own the property. You've given up your interest in it. So you must trust your children implicitly, but also it's theirs for all purposes. So if they were to divorce, your property will be in their financial assessment for divorce. You could lose your security of residence. If they become bankrupt, the trustee in bankruptcy will class your property as an asset in that financial assessment, and again you could lose your security of residence. And finally, and hopefully this will never happen, but if a child of yours were to die before you, they own your property, that property will pass in accordance with their will. If it passes to a spouse, then that spouse may then remarry and your house becomes an asset of your daughter-in-law or son-in-law's new marriage. And again, you could lose your security of residence. So while you still can gift to children, there are a number of drawbacks and negatives to doing so. If you gifted to children within 6 months of going into care, then your children will have to pay for your care because they will be treated as deliberate deprivation. Having said that, there is no time period where you can safely make a gift in lifetime for care fee planning. There is no 7-year period that is just for inheritance tax. So any period may pass and the local authority could look back at that gift. So the other option, rather than passing it to children, is to pass it into a trust. Now, I will talk about trusts again in a little more detail, but I thought that the trust that we would normally give a property in life is a discretionary trust, and that forms protection around perhaps from care fees, but certainly from divorce, from bankruptcy and death. And that's because you're gifting your property into a trust, and the trustees could be you, it could be your children, or a combination, and you hold that property for a class of beneficiaries that you dictate. So you say, for instance, if I made a trust, I would be the settlor, I would gift it to myself and my husband as trustees, and we would hold that property for ourselves, for our children and for our grandchildren and any other members that you would potentially want to benefit. However, no one in that class of beneficiaries has a right to anything in the trust. It is not in their estate for any purposes. So if my daughter were to marry and divorce, then that property is not in her estate and it cannot be used in a financial assessment. It's protected within the trust because no one has a right to anything. But that also means you have a slight lack of control, I suppose. It depends on who your trustees are. So the choice of trustees is really important. Trustees generally make decisions on a unanimous basis. And again, it's just important to think about trustees, who gets on well, who has the right level of knowledge about trusts, about the things that you need to consider. So while a trust can protect from divorce, from bankruptcy and death, it's still never safe from care fees. We can never say it is. It was safer before the Care Act 2014, but since then, the Care Act has introduced deliberate deprivation. And they can say that the reason you gifted the property or any asset into trust was because you wanted to deplete your estate to avoid paying fees. And what they say is that the reason for the gift is that you envisage the need for care in the future. And they say that the people who envisage the need for care are those people who may have retired, or they would suggest are elderly, although they don't actually give a date range. So it's quite encompassing. The other change that the Care Act made, the other unwelcome change, I have to say, is the onus of proof. Now, what I mean by that is that previously, if you put your house into trust in your lifetime, it was for the local authority to prove that the reason you did so was to avoid paying care fees. But now, the local authority can say, actually, you gifted that into trust, and I think it was because you were avoiding paying care, and therefore I am taking the value of your property and I am including it in the financial assessment. And it is for you, the trustees or the person who gave it into trust, to prove that they didn't gift because of care fees. And the final thing that they changed was that rather than it having to be the reason that you made the gift, it just has to be a reason. So you could gift because you wanted to ensure that it's not going to be in your estate on death, to try and prevent someone claiming on your estate, or you wanted to put it into trust because you thought your children might divorce and you wanted to protect your estate. But if the local authority still think that a reason could be to minimize your care fee bill, they could still class it as deliberate deprivation. So a lifetime trust has lost some of its appeal unless you're gifting at a younger age. Now, the other downside of gifting in this way is, whilst it is a gift with a reservation of benefit unless you're paying a market rent to the trust, it may not qualify for the residential nil rate band because it's not closely inherited. So they're the kind of pros and cons of gifting in lifetime. Let's move on then to whether is there any other way to protect your estate, and I would suggest a gift in your wills. Now, why does this work when gifting in life doesn't work? Well, the reason it works is because in English law we all have testamentary freedom. So we can leave what we have to whoever we want. There are some restrictions, of course, through the ability to make claims on estates, but they're limited. So with a will, obviously, for a trust in your will or a gift in your will to become effective, you have to die. So anything you do in your will only become effective on death. So if you are a couple and you both went into care in your life, a gift in your will wouldn't work because the trust isn't, or the gift is not effective. And I suppose just on that point, if you went into care in your life, but your spouse still lived in the property, the value of the house is outside of your estate for financial assessment. It's only if you were both to leave the house to go into care would it be within your estate for financial assessment. So while one of you is still living there, it is actually safe. So this is why, and because it is unlikely that both spouses would go into care in their lifetimes, although not unheard of, a gift in your will can work. But what it means is that you will only be able to gift what is in your name, not what is in the survivor's name. So when you own a property jointly, you can only gift your share in the property. So your share of the property could be safe from care fee planning. For instance, if you left a half share of your house to your children on the first death, then that share would be outside of the survivor's estate for care fee planning purposes. So one half share of your property would be safe from financial assessment for care fees. However, if you do gift to your children, then of course it is in their estates for death, divorce and bankruptcy. I'm full of doom and gloom, aren't I? I'm sorry. But we have to advise this, you know, your security of residence is so important. So the other alternative is a gift into trust. And both for a gift into trust and a gift to children, you have to own your property the right way, and you must own it as tenants in common. So not as joint tenants, but as tenants in common. When you own as joint tenants, what happens on the first death is that the property automatically passes to the survivor. So it doesn't go through your will, it passes by right of survivorship. But when you own as tenants in common, you each own a share in the property, and the first to die share of the property can then pass in your will, whether it's a gift to children or a gift into trust. Now, the two different types of trust that I would advise are what's called a life interest trust or interest in possession trust, and the discretionary trust that I talked about earlier. And there are advantages and disadvantages to both, which I will run through now. So when you give, let's think you own the property, you both own a half share because you own it as tenants in common, and you decide to leave the surviving spouse a life interest or an interest in possession. That means that they have a right to live in the property for the rest of their life rent-free. Obviously, they own the other half as well. If you were to move out of that property, if the survivor were to move out of that property, they would also have a right to the income that property generated. So if they moved out and rented it out, they would have a right to their half share of the rent and the trust's share, because it's the survivor would be classed as what's called the life tenant. The thing about a life interest trust, however, is that they have no right to the underlying capital. So let's say a house is worth £350,000. One half share is worth £175,000. You leave your half share into a life interest trust for your spouse. They have a right to live there. They have the right to the income that property generates, but they can't use that £175,000 if you sell that property. That is still in trust. So if you sold the property, that £175,000 is in the life interest trust. They could invest it. They could use Andrew and Jonathan, invest that £175,000. The life tenant would have a right to the income, the right to the dividends or the bank interest, but they would have no right to the underlying capital. They could downsize and the trust could purchase the new property, and any excess again could be invested, but they have no right to the underlying capital. Rather, on the survivor's death, that underlying capital passes down to your next choice of beneficiary, who are called the remainder men or women. But say they're down to your children. So this can protect your half of the house from care fees because the survivor has no right to that underlying capital. It is possible to build in a little bit more flexibility and control to be able to give capital to the spouse, but the more you build into that, the more the local authority could say, well, you could have that capital if you wanted. It's a bit of a grey area because we don't know exactly how local authorities will deal with that, but it's something to consider. The other thing that has been done, I have to say, further south than here, in London, is then they've got a life interest, they've got a right to live there, they've got a right to income, but not the capital. But what the local authority has done is tried to place a capital value on that life interest. So the half share of the house might be worth 175,000, but they say, well, sure, you can't have the capital, but you've got a right to live there. So I think that's worth about £50,000, and they use that £50,000 in the financial assessment. The good thing about a life interest trust is that it allows you to qualify for the residential nil rate band because the life tenant is the spouse and your remainder men can be your children. Let's move on to the discretionary trust, which I know I've talked about briefly. So I'll just remind you that in a discretionary trust, you leave your half of the house in a will in a discretionary trust. The survivor, the children, the grandchildren, no one has any right to that house whatsoever. It is entirely up to the trustees, who you have decided who they are in your will, to decide who benefits. Now, of course, the survivor owns the other half share, so they've got a right to live there. But what we do with a discretionary trust is we write a letter of wishes saying, I've created this trust because I want to protect my assets. I want you to consider my wife, my husband as the primary beneficiary. Do as they want, sell when they want, try not to pass on capital because I'm trying to protect it, but if they're in financial difficulty, give them capital. But really, I am trying to protect the capital for my children. And therefore, on the death of the survivor, there's still a discretionary trust that needs to be wound up, passed down to the children, or kept for their inheritance tax planning. But as I said, if they've got no right, none of the beneficiaries have any right to anything. And that means that if the survivor went into care, the whole of that half is protected from care fees. It's left in a will. No one has a right to it. You can't put a capital value on it. It does give, a discretionary trust is a really flexible vehicle. So like I mentioned earlier, on the survivor's death, the children could decide, well, actually, we've got half a house in this trust, and that means it's not in our estate for inheritance tax. So it might be useful to keep this trust. So they can benefit from it still. They could perhaps loan themselves money. The trust could act as a bank, so they could buy property, but it would not be in their estate for inheritance tax or divorce or bankruptcy. You can build into control in a discretionary trust. You could, for instance, give the settlor or your spouse the power to appoint and remove trustees, which thereby gives them control of the trust fund. But again, the more control they have, the less protection it gives from care fees. So I'll try not to talk much more, but just to say that with a discretionary trust, there is no residential nil rate band automatically. It is possible to change the structure of the trust to give a life interest to claim that residential nil rate band, but it's not automatic. So I think my main message is, I need to stop talking, otherwise I'm going to go over into Jonathan's, is for you to identify your priorities. Is it inheritance tax? Is it care fee planning? And then look at the structure of your estate. Consider how you own things. Is it joint tenants? Is it tenants in common? Think about whether you want to make lifetime gifts. Are you in a financial position to do so? We don't want it to affect your quality of life. And finally, look at your wills. Do they need a review in light of care fees, in light of tax? Okay, I will leave it, but again, if you have any questions, pop them in the chat and we'll answer them later. But I will pass on to Jonathan, who, as Andrew said, is a financial planner at 1825, who provide advice in respect of investments and inheritance tax protection. But Jonathan's specialist area is pensions and retirement, and he'll be guiding us through pensions, what happens to your pension fund when you die, passing your pension on to loved ones, and keeping your pension within your bloodline. Jonathan and I will answer questions you may have at the end of his presentation. So again, please let us know your questions and we'll answer them as best I can. I'll pass over to the highly intelligent and informative Jonathan. Thank you.
Thanks, Sam. Where do I go from that introduction? This afternoon, as Sam and Andrew have said, I'm going to be talking about pensions, pension death benefits, and keep them within your bloodline. Unlike Sam, I'm going to use the support of a presentation, so hopefully I can bring this up on screen for everybody to see. And I'm sure our facilitators will keep us on track. Looks like we're there. So we're looking at protecting your pension wealth. Okay, so on my agenda today, we're looking at pensions being an ever-evolving beast. What would happen to my pension fund when I die? Passing your pension on to your loved one and keeping pensions within your bloodline. I'm just hoping I can see the script there. So just a little bit of information. The planners based in the County Durham office are David Knight, who is joined as a attendee today, myself and Andrew, and we'll be sharing our contact details towards the end of the presentation. So pensions as a ever-evolving beast. What do I mean by this? Well, since here we are. So the shape of pensions has constantly been evolving. For the purposes of clarity, the purposes of the following slides is relating all to defined contribution pensions, such as self-invested personal pensions, and many income drawdown plans. The rules differ for final salary schemes, and that would take me the entire afternoon to cover every possible permutation there. In 2006, we had the advent of pension simplification, which was supposedly going to bring all the previous legislation under one set of rules. But as the Inland Revenue found at the time, this wasn't entirely possible. And therefore, we've been, you can see my my notes. Let me just remove those. As you can tell, this isn't a system we use very often. So high percent. There we go. Hopefully everything's hidden there now. So yeah, as I was saying, in 2006, the Inland Revenue introduced a new set of rules, which are supposedly going to simplify matters. But as time went on, the Inland Revenue discovered that they needed to put some provision in to protect previous benefits. So we've had a complete change over the years. So we've kept some of the old rules, but we've also had to introduce some of the new. So next slide. So most people, many people ask me what happened to my pension fund when I die. Broadly, this is broken down into two sets of rules depending on the age of the individual when they die. So should death occur to the pension holder prior to age 75, their pension benefits would pass tax-free to their beneficiary, nominee, successor, or separate pilot trust, which I'll come on to speak about later, and could be drawn as a tax-free drawdown payment, so that's income, via a lifetime annuity, a guaranteed source of income for life, or as a one-off lump sum. The thing to be mindful there is if you were to take the pension fund as an entire lump sum, or your beneficiary were to do that, then that money would sit well within their estate for the purposes of inheritance tax. However, should you die past the age 75, then the pension fund still passes to your beneficiary, nominee, successor, or side trust tax-free, but any income or capital drawn from those arrangements will be subject to tax in the hands of the recipient. As you can see, there are a number of caveats or asterisks on the screen to say that there are certain rules that apply in the case of all of these. So in particular, in the event of death over the age of 75 and payment to a pilot trust, there would be an immediate tax charge of 45%. However, any future payments from that trust would be treated as tax paid, and the beneficiaries may be able to recover the overpayment of tax there. So in simplicity, death prior to tax, prior to age 75, the proceeds would be completely tax-free. post age 75, they would be subject to tax in receipt by the individual. So if we have a look at some of these, some of the caveats there where tax may occur in the event of payment of death benefits under a pension. Death benefits from pensions need to be paid within 2 years of the date of death, or within 2 years of the pension scheme administrator being reasonably aware of the death of the policyholder. And as you can imagine, most pension schemes providers are very keen to ensure they make their payments within this 2-year window, which may mean that the payment is made subject to payable to the estate of the deceased, especially in areas where there may be conflict or disputed claims. As I mentioned earlier, payments to pilot trusts where the deceased was over the age of 75, there is a 45% tax charge payable there. And as I said, they could be recoverable. Pilot trusts are not without their complications. A pilot trust is a form of discretionary trust, which Sam mentioned earlier, and they fall under a taxation regime where, should the value of the trust exceed an individual's lifetime allowance for inheritance tax allowance, then there may be tax charges on the 10th anniversary. Third area where tax may be payable is if there's been a previous transfer in the 2 years prior to death, whilst the policyholder or the pension member was knowingly in ill health. This again is a subject we could spend the entire afternoon discussing, but broadly speaking, the Inland Revenue view any transfer from one pension arrangement to another as an opportunity for that policyholder to nominate their beneficiaries as their own estate. Now, having spent 25 years or more in my role as a financial planner, I've not once come across a client who would have nominated their estate as their pension beneficiary in the event of their death, but the Inland Revenue regards that as a transfer of value because it is an option, and what the Inland Revenue would look to charge inheritance tax on at that stage is the loss of capital to the estate. So not necessarily the entire value of the pension fund, but its perceived value in terms of loss of income to the estate. As previously mentioned, where there's potential for delayed claims, or where the nomination of the pension benefit is to the estate, and this often occurs with older style pension contracts which were set up prior to 1990, where they were established under contract law rather than trust law. And in the event of those pension contracts, the death benefits are payable to the estate and are subject to inheritance tax, but can be placed in trust during the member's lifetime to ensure that they pass to the rightful beneficiaries. And the last common area where we see tax payable in the event of death of the pension holder on their pension fund is if the value of their pension fund exceeds the lifetime allowance. Lifetime allowance was introduced in 2006 and has gradually changed from the heady heights of £1.8 million to a reduced value of just over £1,070,000 currently. And the lifetime allowance is typically tested under one of three scenarios: either on full retirement, so when the maximum pension lump sum is taken from a pension contract, on death prior to age 75, or at age 75. So if an individual dies under the age of 75 and their pension fund exceeds the lifetime allowance, then the pension scheme would need to settle a potential 55% tax charge on the surplus at that stage. So how do we ensure that we can pass our pensions on to our loved ones? Well, the most straightforward method of passing benefits within your pension onto your loved ones is via an expression of wish. An expression of wish is typically a form provided by a pension provider or death in service provider for those within employment, where you can write to the trustees of the pension scheme or life insurance provider to outline what you'd like to happen in the event of your death. And quite commonly, this is to spouse or children. Following the changes of rules in 2015 regarding pension death benefits and pension freedoms, the term successor came along. And a successor is anybody who wouldn't be deemed as your financial beneficiary. So this could be grown-up children, it could be great-grandchildren, or wider members of the family, nieces, nephews, etc. Most pension providers, in our experience, will only provide successor benefits if the individuals are named on an expression of wish. So it's quite common to see on an expression of wish that either 100% or a very large percentage of the benefits are expressed in direction of spouse, but then smaller entitlements or 0% entitlements to children or grandchildren. And this means, akin to the doorman of the 1990s, as long as the names are on the list, then they're allowed the full range of benefits under that pension. It doesn't mean if their names are not on the list that they wouldn't benefit from the pension. It simply means that the pension provider may not offer the full range. And as we've already sort of looked at, there are certain circumstances, especially if the pension holder was over the age of 75, that tax charges could be paid if the only option is for a lump sum to be paid to a successor. And these can be updated as people's circumstances change. Under UK pension legislation, all pension death benefits are subject to trustee discretion. So if a pension provider such as Standard Life, Aviva, Legal and General were to receive a death benefit claim, they would assess that claim to see whether the expression of wish was on file, and if it was it a sensible direction. There are a couple of sort of occasions I've come across in my career where the pension trustees have exercised their discretion outside of the expression of wish, and this is where there has been potentially frivolous activities, where perhaps a pension holder has named a girlfriend rather than spouse and children who are financially dependent, or where there's been confusion or a discrepancy in the beneficiaries. So in order to assist the trustees in their actions, we would always recommend that when completing an expression of wish, if there are any peculiarities from the norm, that these are expressed in the free section within the expression of wish. Now this could be, I have favoured daughter A as a beneficiary under my pension, as daughter B has received gifts throughout her lifetime to purchase her first property, for example. So as with any kind of financial planning, the greater detail that you can include in your instructions, the more likelihood is that it will be put in place for you. So this is where sort of making your pension wishes known. Here I want to sort of talk a little bit more about pilot trusts or discretionary trusts. Pilot trusts used to be referred to as spousal bypass trusts, as the direction within them was to ensure that there was some control in who would receive the benefits under the pension beyond the grave for the pension holder. And I think this is best explained through an on-screen example. And I'll base it on myself as not to bring any client matters into consideration. So if I was to complete an expression of wish, for those who don't know me, I'm married with 2 grown-up daughters from my first marriage. So I could complete an expression of wish in respect of my pensions in favour of my wife Lucy, with nominal amounts for daughters Lauren and Chloe. So in the event of my death, my pension fund would pass to Lucy, and you would think that in the event of Lucy passing away, she would automatically benefit my children would automatically benefit under the pension. However, on passing of the control of the pension to Lucy, she can then nominate her own beneficiaries as to whoever she likes. So as we are a blended family, she could nominate her sister, her nieces and nephews, rather than my children. If I was to create a pilot trust, I could designate my pension in trust with an expression of wish that favours Lucy, but the trust would have its own additional trustees who'd look after another class of beneficiaries, which would be my daughters. So in the event of my death, my trustees would receive the pension fund, and they could make distributions to all of the beneficiaries under the trust, which would look to protect Lauren and Chloe's interests beyond my death. I feel that sort of the use of a pilot trust is especially beneficial where there are large sums at play in terms of pensions, which Andrew, I and David have seen over recent years, whether that's through many years of hard work accruing pensions or under pension transfers in recent years. I appreciate I've whistled through sort of my section of the presentation, and hopefully there's been of benefit to see this information on the screen. As always, if anybody has any questions regarding this, please pop them into the comment section through chat, and Andrew and I will do our best to answer them. But in closing, I need to show our compliance slide, which I'll leave on screen for a few seconds before returning us everybody on screen and stopping the share. So thank you very much. There we are. Hopefully everybody's back on screen.
Brilliant. Thank you for that, Jonathan. Thank you for your session, Sam. We have had some questions in. One of them was particularly detailed and technical. So after this, Sam, I might ask you to get in touch with that person.
Sure.
I wouldn't want to put you on the spot too much.
No, it's okay. I mean, I don't mind.
So the question that I think is probably more useful for now is one of our clients was asking, and I would think this is in relation to perhaps property trust and transfers, was are there any tax implications that come with a discretionary trust? And then they also asked, or if I own my property as tenants in common, is it safe?
Okay, well, I think, Jonathan, you touched on the tax regime for discretionary trusts in your presentation, in that if the value of the trust fund is over the nil rate band, which is currently £325,000, on the 10th anniversary, there is a potential charge to inheritance tax on the value over that nil rate band. So again, if it's 350,000, £25,000 is potentially taxable every 10 years at a maximum rate of 6%. So yes, there is tax associated from an inheritance tax point of view with a discretionary trust, but it's 6% every 10 years. So it's a lot less than the 40%. There is also tax for income. So the first £1,000 is charged at normal rate, so 20% on interest and 7.5 on dividends. But thereafter, if the trust has more has more income than that, dividends will be charged at 38.1%, and all other income will be taxed at 45%. So yes, there are some tax implications.
So just the second part of that question was about, I think it linked
tenants in common.
Or if I own my property as tenants in common, is it safe? So I suppose trying to build that out, I guess maybe perhaps the question is tenants in common by itself sufficient, or actually is there often a need for more?
Yes, so tenants in common just says that you own separate shares of the property. It's normally 50-50 unless you've got a declaration of trust that says I own 70 and you own 30. But that in itself isn't really sufficient. It just means that your share of the property will pass down through your estate, whether it's through your will or through your intestacy. So generally we sever tenancies to make sure they're tenants in common if we're going to make a gift of the property. So there needs to be a gift of the property within the will to have effect. You need to gift it to children or into trust to be able to get that sort of protection. So just owning it as tenants in common isn't sufficient. You need to have it in conjunction with your will.
Okay, thank you. One for Jonathan, I think. So we've had this asked twice. So it relates to, as my circumstances change, I presume I need to keep my expression of wishes up to date. And I think that then links to another one which says, can I change the beneficiaries?
Yeah, absolutely. You can change your expression of wish at any time simply by completing a new one, a new form or new letter and sending it to the pension scheme administrator. And it's advisable to do that any changes to your circumstances as you would and should with your will. So marriage, divorce, birth of children, and should parents pass away. So yes, it can be updated. As planners, we tend to discuss this on an annual basis with our clients at their annual review to establish whether there's been any changes. But it is a simple, straightforward process.
Okay. And then one more sort of general question, which I suppose in the interest of fairness I should take. So it was a client asking, do financial planners charge for advice in the same way as solicitors? So I suppose the distinction I would make is my understanding, and Sam I'm sure will correct me if I'm wrong, is that most solicitors will tend to charge on either an hourly or a fixed fee basis, depending on the work that's being undertaken. Whilst some financial planners might charge in this way, sort of hourly or fixed fee, it's more common in our industry that charges are a percentage of the amount of investments on which we're advising. As I say, there are different structures, but it's more common to see percentage-based charging. As always, we'd encourage people to shop around, speak to a range of professionals to understand what they're paying and that they're comfortable with it, really. Do you have anything to add on the way that you charge clients, Sam?
No, you're absolutely right. For wills, we would always give a fixed fee so that people knew what they were paying, and it's generally for work that takes a long period, like an estate administration or trust administration, where we would charge by the hour, so that we're only charging for the actual work we do. That's how we would do that. Okay,
brilliant. I don't think there's anything else. As I say, there's one other question which we'll pick up away from today. So I think all that leaves me to say really is that thank you for people for attending. Hopefully it's been interesting. If there is anything that anyone has questions about, please don't hesitate to contact either myself, Jonathan or Sam. Our details are on the screen now and we'll leave them up for a minute or so. We are conscious that there are a lot of these webinars going on at the minute. As I mentioned, we have recorded this one, so we will be distributing it. So if there is anyone that you think might find it useful, please do share the link with them when you receive that. Other than that, just thank you to Sam and Jonathan, and we will hope to speak to you all soon.
Thank you. Can I just add one last thing? It's just that my name hasn't got the N on the end of Samantha, rather than Samanthan. It's just Samantha. That's all.
Oh, on the email address, sorry.
Yeah. You can call me what you want though, really. Thank you, everyone.
Thank you very much.